Hi everybody, how are you? Thanks very much to Mark and Endeavour and the Public Advocate and the people organising this for inviting me here today. I'm from Queensland Advocacy, as Mark just explained, and Queensland Advocacy is a disability advocacy organisation over in South Brisbane. We have a number of programs. I'm a systems advocate, but we also have a mental health legal service and a human rights legal service and a justice support program that is specifically set up to assist people with impaired capacity, including people with intellectual disabilities, in their relations with the criminal justice system. You may remember that a few years ago Queensland Advocacy produced a report called Disabled Justice in 2007. That was commissioned by Kevin Cox, who was then QAI's director. He got Philip French from the Intellectual Disability Rights Service in New South Wales to write that report. And at the time it was, I think, reasonably influential on the Labor government at the time. And it was influential in the setting up of some of the disability policies of the Queensland Police Service and Justice. So the reason that I'm here today is that we're doing an update of disabled justice, and to that end I'm interviewing people who are working in the criminal justice system, so criminal defence lawyers, magistrates, legal academics, psychologists, people in forensic disability and so on, to get their views about what are the holes in the net, if you like, what are the problems in the system, and there are many. So I'm not going to attempt to talk about all of those today. I'm just going to focus on a few things. First of all, overrepresentation, and unfortunately I may be repetitious here. I wasn't here, unfortunately, for some of the morning presentations, but I'll go through a few slides about overrepresentation of people in the system. I'd also like to talk about the experience of people with intellectual disability as defendants. And I think importantly I'd like to talk about the relationship between the fact of intellectual disability and criminal responsibility, because they're quite different things and they don't necessarily mesh very well. And I'd also just like to talk briefly about the pros and cons of the identification of intellectual disability at various stages through the criminal justice process, particularly whether or not it's appropriate or practical for the police to identify people with intellectual disability, for the police to administer a test, for example. And from the people that I've spoken to so far, for the purpose of this research, my impression is that it may not be best to get the police to carry out any kind of test with people to determine intellectual disability. I get the sense that the focus should rather be on capacity generally and the need to provide supports, including decision-making supports for anyone with impaired capacity, whether that be in relation to intellectual disability, fetal alcohol syndrome, mental illness, or any other capacity-related issue. But before I go on, just let me talk a little bit about overrepresentation. The relationship between intellectual disabilities and offending are complex, so while the research is unanimous in its conclusion about overrepresentation, there is no consensus about the precise degree of overrepresentation or the reasons for it. So looking at the research, of course there is some general research, Kathy Allen's research, Kate Van Duren over at QSID, the work of Ed Heffernan over at Forensic Disability into ATSI people in prison, but there's not a lot in Queensland about overrepresentation. The most recent study that I'm aware of was a 2002 study by Queensland Corrective Services. Another problem with the research is that there are different levels of intellectual disability: borderline, mild, and moderate, and different. So there's not so much of a focus on the relationship between disability and capacity. And a third deficiency of the research, I believe, is that there's no consensus about how the fact of intellectual disability should inform justice and corrective policy. Just to explain something about the relationship between intellectual disability and criminal responsibility, one of the important things to remember is that there's no clear dividing line between people who have intellectual disability and people who do not. And in the research you'll see that there is a lot of reference to people with borderline intellectual disability. So you'll see there on that classic IQ bell curve that you have 2% of people at the bottom of the curve who have IQs below 70, but a large cohort, about 14% of the general population, who are in that borderline range. So most importantly, this slide demonstrates that the way IQ scores are in fact a continuum, and the IQ-based definition captures everyone below 2 standard deviations from the norm. It's a black and white divide, when we know, in fact, in real life we're dealing with grey. It's something to keep in mind when I talk about the relationship between intellectual disability and criminal responsibility. This is a slide about IQ distribution in the general population. As you can see, about 2% of people have an IQ below 70, and that's the classic definition of intellectual disability. Then another 14% in the borderline range, and then everybody else above that. Here's a bar graph of the distribution in Queensland prisons based on the study in 2002. As you can see, 10% of people with intellectual disability, 29% of people in the borderline range. And here's the two graphs up against one another. As you can see, there's a huge overrepresentation of people with intellectual disability in prisons, and again, a huge overrepresentation of people with borderline intellectual disability. Susan Hayes has been one of the premier researchers in this field over the last 30 years, and her mid-1990s research in the New South Wales local courts determined that about 37% of people appearing there had intellectual disability and borderline intellectual disability. That figure is consistent with the one arrived at by Corrective Services in Queensland a few years later. So we have people with intellectual disability being imprisoned at about 5 times the rate of the general population. So how do we treat these people differently? Why do so many people with intellectual disability end up in trouble with the law? And what is the impact of intellectual disability, for example, on criminal responsibility? For the vast majority of defendants and prisoners, the answer to that last question is not much. Intellectual disability has little direct impact on criminal responsibility because of the way criminal responsibility is assessed. There's been some research done into this question in the US, and Petrella found that of criminal defendants with intellectual disability, about 90% of people with mild intellectual disability are found to be criminally responsible. So that's people in the IQ 55 to 70 range. And 67% of people with moderate retardation, which is the expression used in the US, are found to be criminally responsible. So there's no doubt that the proportions are the same or perhaps higher, given that here in Queensland we have roughly 200,000 criminal matters before the courts each year, and by far the great majority of them are heard in magistrates' courts. And there's no determination of capacity at all in the magistrates' court in relation to simple offences that dominate there. I can explain what this means by reference to a case example. I went to Holland Park Magistrates Court a few months ago. We were fortunate to have the opportunity to talk to Colin Strofield to get his observations. He told me that one of the frustrating challenges for magistrates is that there's no determination of capacity in relation to simple offences. So unlike in relation to indictable offences, there's no alternative process for people who lack capacity. He related the example of a young man who presented to the court on a charge of trespass, theft and willful exposure. The young man had taken a frozen chicken to the local pub and asked them to cook it for him. And when they refused to do so, he went down to his local school and ate it there. That's where the police picked him up. Because of the children's safety issue, together with the later exposure offence, in the magistrate's words, he had no choice but to find him guilty and record a conviction, despite the fact that the young man clearly did not have the capacity to understand that what he did was wrong. The magistrate guesstimated that about 10% of people who appear before him have intellectual disability or some other capacity impairment. I don't want to suggest that the criminal justice process doesn't work all the time. I spent some time with a legal aid duty lawyer at Beenleigh Magistrates Court. The duty lawyers work under a lot of pressure, representing perhaps 20 to 30 clients each morning, and they need a thorough knowledge of the facts in each matter in order to plead in mitigation. The duty lawyer represented another young man, about 18 years old, who had a hypoxic brain injury after a severe asthma attack, had cut off the oxygen supply to his brain. He was charged with public nuisance in relation to the non-payment of a taxi fare. He and some mates had got stuck after a party at Wynnum in the small hours of the morning and had called a taxi. And when the taxi arrived, the driver demanded cash up front. They didn't have any money, and there was an altercation afterwards. The young man, according to the police facts, had attacked the taxi driver with an iron bar, or at least threatened to do so. The duty lawyer advised the defendant that if he pleaded not guilty to the assault charge, claiming that he had not been involved, the matter would go to trial. And that could take months and end up with a much worse result for him. I mentioned to the duty lawyer that there's a program called Queensland Courts Referral, which is I suppose the second iteration of the Special Circumstances Court. But after conferring with his parents, the young man decided to plead guilty. The magistrate listened to the solicitor's arguments in mitigation, specifically mentioning the young man's disability, and the magistrate took this into account. He accepted that his disability may have affected his judgment. He recorded no conviction and issued him with a small fine. The key here is that capacity impairment was brought to the court's attention by the duty lawyer. But when should it happen generally? The police have a vulnerable persons policy mandated by the Police Powers and Responsibilities Act, and that policy, in my view, should be strictly implemented. It's well established, for example, that in custody, people with intellectual disability have more difficulty in understanding written information detailing their legal rights when compared to offenders without intellectual disability. When questioned, they are more likely to be suggestible and to acquiesce to statements made to them. They are more likely to misunderstand basic legal terms such as guilty and not guilty, and they are more likely to presume that a false confession is transparent and reversible. So there's a question: shouldn't there be a mechanism for the identification of people with intellectual disability as soon as possible after first police contact, so that people can be provided with supports? From my own experience talking to people with expertise and experience in this area, there seem to be two schools of thought on the question of identification. First, there's the view that people with intellectual disabilities should be identified early in the criminal justice process so that they can be treated differently, diverted off into some alternative process and provided with special supports. To this end, for example, Susan Hayes has developed her HARSI test that has been trialled by Legal Aid in Queensland. The second view is that people should not be arrested and charged and processed any differently than anyone else based on intellectual disability alone, and that the question of criminal responsibility and fitness for trial should be tested using the same mechanisms as applied to everyone. The idea is that not much that is productive will come from identification, and some people, as Kathy alluded to, may feel disadvantaged by it or not identify as having an intellectual disability. And from a public interest point of view, identification, the police administering a test to every criminal defendant can be time-consuming, expensive, and provide little return. My own view, for what it's worth, and I don't have any particular expertise, is that the negatives of testing may outweigh the positives, both on principle and in terms of cost and practicality. It may not be worthwhile to identify intellectual disabilities per se. In my opinion, the important issue is not intellectual disability specifically, or acquired brain injury, or FASD, or mental illness. It's the question of capacity. It's capacity that matters when counsel has to consider whether the person can instruct a defence, when the court considers whether the accused has the capacity to understand and participate in court processes, and in sentencing, capacity affects moral culpability, deterrence, and the retributive experience of imprisonment. It's controversial that in Queensland, as I mentioned before, the determination of capacity is not at issue when any person other than one already on a forensic order or an involuntary treatment order is charged with a simple offence. The fact that the courts don't determine capacity in regard to simple offences is the reason that Melissa Avery, who some of you may have heard of, came close to going to jail. She has moderate intellectual disability, and she likes to collect postcards unpaid for from her local newsagent. She had to go to the Supreme Court to have her convictions quashed in relation to those thefts. And the fact that our lower courts, unlike those in New South Wales and Victoria, have no determination of capacity is arguably the reason why lots of other people with significant capacity impairments go to jail. So capacity matters a lot, but mostly at 2 points. First, at the time of the alleged offence, if you don't have the capacity to control your actions, or to understand what you were doing, or to understand the difference between right and wrong, then you should not be considered criminally responsible. And if you do not have the capacity to understand court processes, then you are not fit for trial. The problem here, though, is that intellectual disability impacts differently on people's capacity in those terms. So while some people with intellectual disability may be criminally responsible and fit to plea, some are not. And that, in my view, should be determined on a case-by-case basis, consistent with a social understanding rather than a medical understanding of intellectual disability. To sum up, what the experts have been telling us so far is that first, we need better resourced mental health liaison persons and duty lawyers with a background in mental health who can assist the courts in efficient, on-the-spot determination of capacity. We know from the forensic system that it is not efficient, for example, to engage psychiatrists to determine capacity because of the delays involved. Secondly, we need the determination of capacity currently available in relation to indictable offences to be extended to simple offences heard in the magistrates' courts. And finally, we need better sentencing options available to magistrates so that people can get appropriate supports to live their lives without finding themselves lost in the forensic system. And it's encouraging to find that at least one of these options is on the cards here in Queensland now. Most of you will know that there's an issues paper in relation to the review of the Mental Health Act, and that issues paper includes the recommendation that where a magistrate is satisfied that a person is likely to be or appears unfit for trial or of unsound mind due to intellectual disability, the magistrate must discharge the person unconditionally and may refer the person to the Department of Communities, Child Safety and Disability Services to consider whether appropriate care can be provided to the person. So I urge you, if you're able, to support this and some of the other recommendations in relation to that review. Thank you.
Question?
Yep.
Thank you for this presentation. Just two questions. On the statutory reforms proposed here, if capacity matters, and obviously that's to be tested at different points in time, depending upon where patients are. Is there a risk associated with giving a magistrate the power to, or requiring a magistrate to discharge a person on condition?
I think that yes, I think there is a risk, but presumably that would only happen when there was some other expertise to back that up.
Yeah.
I don't think a magistrate is in a position to make any kind of a judgment about capacity on his own, on her own.
That leads me into my next question, and that is, I mean, I appreciate the capacity, the legal test of capacity matters, but is there a role for experts to play in informing that judgment with expert evidence? So I acknowledge what you said about psychiatrists, but certainly psychologists, would you think that they'd have got something to offer in terms of providing evidence upon which an assessment of capacity can be based?
Well, I think the issue is that there's so many matters going through, as I alluded to before, around 200,000 per year. Criminal offences generally, including simple and indictable offences. I don't think it would be practical to have psychologists on site at every magistrate's court to be assessing capacity.
Yeah.
It is a conundrum. I mean, and certainly, as I alluded to before, it's not practical to have psychiatrists doing it either, because as you're probably aware, there's been an issue with the Section 238 reports. People can sit on remand for, I mean, we know of instances of people sitting on remand for over 18 months waiting for those reports. So I don't know what the answer is, but I think there needs to be some determination of capacity by someone with some degree of expertise. They may not be a psychologist or a psychiatrist, but it's somebody preferably on site.
Can I just be forgiven a third and final comment / question? Doesn't the complexity and the cost associated with expert assessment of people brought before the court in individual cases mean that, and I recognise that this is what I'm about to say is controversial, mean that maybe what we need to do is actually have assessments of people, work out whether there is an issue with intellectual disability, and then have that noted on a file that's available electronically to all the people in the system. So that when they come before the police or the courts or what have you, and I realise this is a controversial proposal, so that the service systems are aware that that's an issue and can take action accordingly. It seems to me that
Possibly, but
yeah, I mean, because I understand what you're saying about the social construction of disability, and I agree with you completely as a matter of theory that that's appropriate. But I wonder about the efficiency of that.
Well, I'm sure I didn't explain it very well, but there's a very distinct difference between having an intellectual disability and the issue of criminal responsibility. So criminal responsibility is determined by primarily by those three factors that I mentioned before: whether you understood what was going on at the time that the alleged offence was committed, whether you knew right from wrong, whether you could control your actions. So intellectual disability doesn't necessarily mean that you are not criminally responsible. And as those stat from Petrella showed, 90% of people with mild intellectual disability are found to be criminally responsible. So I'm not sure whether assessment of intellectual disability per se is the issue. The capacity is particular to a time and place. So it's the issue of assessing the person's capacity at that moment in time, not at any other time. And that's very much something that the courts need to determine, because they're the experts in criminal responsibility. So I don't know, maybe there's an opening for someone with a degree of training in the law who can, the ideal person that comes to mind is the duty lawyer, I suppose, or someone attached to the duty lawyer who can make some sort of quasi-expert assessment of that person's capacity in relation to the offences.
It's a question of...
Well, I was just going to say, and I mean, this is probably coming from my background. I'm one of the permanent legal members at QCAT, and there is a significant body of expertise in terms of assessing capacity that exists in the tribunal. I can't see why that couldn't be also reside in magistrates with the same definition of capacity that's in the Guardianship Act, or why, if the issue was raised, magistrates couldn't, through some change in legislation, refer somebody to QCAT in order for there to be an assessment of capacity. That expertise exists, it just exists in the wrong place.
I think, if I could comment on that, once again, the issue is resourcing and cost, I think, because if we're talking about at least 10% of people...
I think it'd be fair to say that we would expect to be resourced before it's all coming our way.
We're talking about a hell of a lot of capacity assessment.
It does exist, and if it doesn't...
There was another question.
There are people trying to...
Oh, sorry.
Yes.
In regards to competitive courts, I don't know if it had much to do with the court liaison services, the broadcasters.
Yeah.
Someone in the court to help with rectify capacity issues and then be responsible for those referrals at that first point of contact would probably be worthwhile. I'm a typical capacity assessment just to raise that issue and provide consultation to the magistrate. Probably be worthwhile to let the issue rather than just having
I agree. I think that's a good suggestion. Also, better resourcing of Queensland Courts Referral, which is the new program that I mentioned before, that I think is only working out of the Roma Street Arrest Courts and possibly Toowoomba and Ipswich at the moment. But it's a bail-based alternative process. It's done on a fairly informal basis, based on referrals by magistrates themselves, and in some cases by the DPP. But it's a much longer process for people, and that is a factor to consider as well. A lot of, obviously, people find the court process very stressful, and people want to get on with their lives. And in the case of that young man that I mentioned before at Beenleigh, that was a very good outcome for him. I know that he would have preferred to do that than have been diverted sideways into a much longer and more involved process. So it's a difficult one.
Thanks. I'd like you to join with me in thanking Dr. Kathy Ellen and Dr. Nick Collyer for their presentation.